The healthcare industry is governed by the Health Insurance Portability and Accountability Act, or HIPAA. This is run by the Department of Health and Human Services, or HHS. The HIPAA security rule applies to two types of entities: covered entities or business associates. Covered entities include such things as health plans, healthcare organizations, or healthcare providers. They transmit health information in electronic form. Business associates, on the other hand, are providers of data transmission services to covered entities, or a person who offers a personal health record to individuals on behalf of a covered entity, or a subcontractor that creates, receives, maintains, or transmits protected information on behalf of a business associate. And HIPAA only applies to protected health information. It's collected from an individual and created or received by a covered entity. It can relate to past, present, or future physical or mental health, provision of health care, or payment for the provision of health care. But it's only protected health care information if it directly identifies an individual or, on a reasonable basis, could identify an individual. Covered entities and business associates must ensure the confidentiality, integrity, and availability of electronically protected healthcare information. This is the same confidentiality, integrity, and availability that we've had in the security industry for as long as I've been in the industry. But you must take steps to reasonably prevent anticipated threats. And always use any reasonable and appropriate measures to implement the standards of HIPAA. HIPAA provides latitude to determine how you will implement those standards, but it does provide a fairly detailed list of the types of things that should be in place. And there are 4 types of these called safeguards: administrative, physical, technical, and organizational safeguards. There's many of these listed in a book, and I've highlighted a few here to give you an idea of some of the things that are contained within each of these safeguards. Under administrative safeguards, manage security processes to prevent, detect, contain, and correct security violation. So this is sort of that corollary to the statement that you see in other regulations, to have written security policies and procedures. Should conduct an accurate and thorough assessment of potential risks and vulnerabilities, implement security procedures to reduce those risks, and sanction non-compliant employees. Of course, for that provision, you do need to work with your HR department so that they understand the rules as to why you're protecting HIPAA data and why there needs to be a sanctioning if an individual who has access to that data does not maintain a secure environment. Regularly review system activity, designate an information security officer, again that corollary that we see in other regulations, develop authorization processes, basically to reduce the likelihood that somebody who isn't authorized would have access to the health data. Develop procedures to remove access for terminated employees or those who are no longer in a position to have a need to know that data. For physical safeguards, you can think of these as simply how to physically protect the data. So when you think about that, you want to first think about limiting the physical access to the facilities and systems that store protected health information. When I worked for a telecom company, we actually had to physically build walls inside the company to isolate those people who had access to health data from those who did not. Establish business continuity plans, develop procedures and policies to physically safeguard the systems that store the electronic protected health information. And here, one of the things we did to protect the data was to build cages inside of the data center that actually went from floor to ceiling, cement floor to cement ceiling, so that nobody could access the systems where that data was stored. Develop all or document all repairs and modifications to doors, locks, and other physical components. Develop physical safeguards to restrict access to individuals who are cleared to access health information. And here we put up card readers so that people who had their ID cards who were cleared to enter the area where we stored health data could enter that area. And develop policies and procedures for the removal of systems that stored electronic protected health information. And there you want to make sure that if you are removing a device that had stored data on a hard disk, that hard disk is either wiped or destroyed. Likewise with paper records, that it's either shredded, dissolved, or burned, or something that will prevent anybody from having access to that data. Technical safeguards are what you would think about in more detail for implementing some of the practices to protect the health data. So here you might want to develop technical policies and procedures to grant access to cleared individuals. You need to have a known user ID. You have emergency access procedures. We used to call this break the glass, so that if there was an emergency off hours, someone in the data center could give access to an administrator to take care of an issue. Automatic log-offs, specified time of inactivity. So if you walk away from your screen, the screen locks and at some point in time actually logs you out. And encryption and decryption of electronic health information, again using data or using encryption algorithms defined by NIST. So you need to log activity on all systems that store electronic protected health information and save those logs, because if you need to reference them in the case of a breach, you want to make sure that you have the logs available to do that. Develop procedures for verifying an individual's identity before providing access, which could be very interesting if you have individuals that are working remotely. So you have to trust somebody at that site who can verify the identity of the individual. And implement technical safeguards for your networks. Operational standards are usually contractual obligations. So contract with business associates must explicitly require the business associate to comply with HIPAA security requirements. And likewise, if they use subcontractors, they must be compliant with security requirements. And group health plans must state in their document that plan administrators will reasonably and appropriately safeguard electronic protected health information. Interestingly, a breach notification is not necessary if the health insurance or health information has been secured pursuant to HHS guidance. And there's a low probability of compromise. Encryption should be an algorithm validated by the National Institute of Standards and Technology, or NIST. Breach notification may be delayed if there's a law enforcement action. Otherwise, the notification must be made within 60 calendar days. And in that notification, you have to describe the breach, including the date of the breach and the date of the discovery. Which means at that point you've already done some forensic investigation so that you know approximately the date of the breach. There should be a description of the types of unsecured protected health information involved and the steps that individuals should take to protect themselves from harm of identity theft. And a brief description of the covered entities' investigation and mitigation activities, and contact information for more questions, such as a toll-free telephone number, an email address, website, or a mailing address. For the notification process, you can email to the last known email address or postal address if you have that information. Alternative notifications, if you have less than 10 individuals compromised, you could do that notice by telephone or other means. If it's over 10 people, you could do a conspicuous posting on your website for at least 90 days. or a conspicuous notice in a major newspaper. You want to include a toll-free number which is active for at least 90 days, and a telephone can be used if urgent notification is needed. If there's over 500 individuals in a single state compromised, the appropriate state authorities must be notified within 60 days. You must also notify the HHS, and if you'd like, you can go out to the website of the HHS and look at the Office of Civil Rights, and you can see some of the cases of past breaches, which are very interesting to read. They're usually pretty short, but they're very interesting to read.